David Lammy.
Mrs. Reardon, I'm very grateful. There's very limited time. Can I just thank my honourable friend, the member for Westminster North, for bringing this to the House. This is an incredibly important debate and cuts to the heart, frankly, Mrs. Reardon, with the kind of society that we want to live in. And I think it's really important that the House puts on record that we do not want to go back to a time where this work is being done by volunteers. When we talk about justice and access to justice, at its heart is social justice and the kind of society that we want to live in. And I believe that we must live in a society where the most vulnerable get access to justice. Now, I say that as a former minister with responsibility for legal aid, although if we go back to the earlier part of the decade, before the 30 consultations, the sorts of things that I was looking at in relation to fixed fees and new ways for contracting are a long, long way away from the Green Paper that we've seen this morning. And I think I want to begin by just reminding the House what the Prime Minister said in the run-up to the election about family policy. He said that he wanted to make Britain the most family-friendly country in Europe. And just a few days ago, he said that the seeds of so many problems, as well as success stories, are sown in the early years. Family is where people learn to be good citizens, to take responsibility, to live in harmony with others. Families are the building blocks of a strong and cohesive society. Well, I say to him, he cannot make pronouncements like that and then run a coach and horses through family life in constituencies across the country. The services that family practitioners provide for vulnerable families facing breakdown, for people experiencing who should have contact and how that is arranged, is absolutely essential in modern society. And if you take that advice away, apart from in domestic violence cases, I'm afraid we will see chaos. We will see people presenting at court as litigants in person. And of course, when you get to the county court, you can't receive advice from the court clerks and from the judges. You simply get a form to fill in. You are on your own. So what will happen is most often families, but actually women, will not get that advice. And so I ask the Minister to really think hard. Is this the kind of family we want to live in? And is this consistent with an undertaking to put families at the centre of British life? It cannot be, I won't give way because there's so little time. It cannot be right that you will only get a practitioner in the event that you already have an injunction. Are we really saying that a woman should pitch up to court on her own if she's concerned about contact and her husband, who may be violent, having contact to her children? She should make her way on her own in a vulnerable context without access to legal advice. Are we really saying that where families are in dispute, where one parent wants to take a child abroad, that that parent, again, fighting that decision, should find access to justice on their own without sufficient funds? And are we saying, and I say this as the Member of Parliament who had the Baby P case in my constituency, that where there are care proceedings that ultimately end in adoption, are we saying to the many thousands of families up and down the country that they, when adoption in the end is changing the legal nature of that child's relationship with their parents, that they should not be able to be in court with legal aid to fight it or to challenge it if they're concerned that they are losing their children? That cannot be right. That's not the kind of society that we want to live in. Can I also say to the Minister that this is not consistent with a big society? Yesterday we saw the announcement of up to 40% cuts in local government budgets. This means, frankly, a decimation of much of the voluntary sector that the Ministry of Justice says that people should rely on. How can this be the big society? What will happen in a welfare benefit situation, given that many of the groups that support these people, often the most vulnerable with mental health issues, often those who are immigrants, often those who have been without work for some considerable time, how can it be right to withdraw the support that they need at this time of profound change in relation to benefits in society? And then in relation to immigration, can I just remind the Minister of the important, and I think the churches are very consistent with reminding the state about this responsibility, that actually, given that we've pared back so much of the legal advice that's available in relation to immigration and indeed asylum matters, that actually lawyers in this area help the system because they help constituents provide information to the bureaucracy, to the court system, that is actually easy to understand and makes justice quicker. And what this will do, it will drive people underground. It will drive people into ghettos where they cannot be seen or found. People without the right documents, the sorts of things that we see in other parts of continental Europe. We do not want that in this country. So this Green Paper is particularly worrying. It's very possible that you might pass it away as unimportant, but we will not be a civilised country unless we provide adequate legal aid. And in the context in which the previous government had stabilised legal aid, it's my contention that enough is enough. Now is the time to stand up for what civilised really means, and certainly not to if you like, walk alongside hypocrisy by suggesting that we can support family, that we can have a big society, that we can be fair in a civilised democracy, and then run a coach and horses through the vulnerable access that people need to justice.
Andy Slaughter.
Thank you, Mrs. Reardon. Can I first say that it's a great pleasure to serve under your chairship this morning and to be opposite the Solicitor General. And it's been a privilege to listen to so many well-informed speeches on this matter from both sides. It's invidious to pick people out, but I do. My honourable friend, the member for Islington North, and the honourable gentleman for Swindon, who showed decades of experience in dealing with these matters. And I hope that the Minister will listen to that and to other contributions that are made during the consultation process and realise that mistakes have been made in the proposals that have been made to many of the cuts to legal aid here. I particularly pay tribute to my very good friend, the member for Westminster North, who is just standing down as the chair of the all-party group on legal aid and has an unrivalled record in pursuing these matters and for securing this debate today. And like her, I will also mention my not-for-profit agencies. I've had the pleasure to be on the management committee of Hampstead and Fulham Community Law Centre for 20 years, and they do a fantastic job. So too do the other two advice agencies that have been in my constituency, Threshold Housing Advice and the Shepherd's Bush Advice Centre. I say do, I meant did, because the latter two of those have closed this year because of the withdrawal of local authority funding. The Law Centre has lost all its local authority funding and is therefore under threat. And that's a point I'll return to in the general case, but it's a familiar pattern. I think that the practitioners, many of whom who are here today, will be amongst the most astute and trenchant critics of all governments in supporting legal aid, but I think even they would concede that Labour governments over the 60 years since they introduced this have, perhaps 2 steps forward and 1 step back at times, but have increased the scope and eligibility of legal aid. Having said that, and to save the legs of any members opposite who want to get up and read the Whip's briefing about what would you cut, I would say, yes, we were in a period of retrenchment, and yes, there would have been cuts. There would have been cuts. No, I'm not given the time and things I have to say. There would have been cuts under a Labour government. There would have been cuts, I think, to private family law in some respects, although I think we do need to look again at the definition of domestic violence. As the member for Swindon said, there would have been, I think we would have taken a much more forensic look at criminal legal aid, which has just been brushed over in this. What there wouldn't have been, what there wouldn't clearly have been, is these cuts to social welfare legal aid. And I also pay tribute, and he's in the audience here, to the Noble Lord Bark, who over a period of years as the Minister supported and defended and spoke out for social welfare law, and I think that we have done a very good job in protecting that and would have gone on protecting that. And that is the real problem, and given the short period of time we have to debate this morning, I'll devote my remaining comments to that and follow the lead given by members speaking today. The briefing from CAB says this: the proposals to exclude most social welfare law issues from scope will mean over 500,000 fewer people getting help every year. That is the first statistic. What type of people are we talking about? We've heard many examples. Parents going to special educational needs tribunals, tenants facing harassment or disrepair, disabled people whose welfare benefits have been cut, people who have been wrongfully or unfairly dismissed. And yet, in the vision section, no irony I'm sure intended, of the business plan for the department, it says, a legal aid system that supports those most at risk, not those who are most litigious, is the aim of this programme. I don't see those people as the most litigious. I see those as the most vulnerable in society. When the Lord Chancellor made his statement to the House on the 15th of November, he talked about back to basics principle of the Green Paper. Well, this is very basic indeed. I think a truer account was given in the Sunday Telegraph the day before. If you want the fullest account of government policy, you always look in the papers the day before the statement's made to the House. And what the Sunday Telegraph, I guess no great friend of legal aid, said is this: legal aid for civil cases will all but disappear. Is that an exaggeration? I think not, Mrs. Riordan. 23% cuts in the Ministry of Justice, which is one of the highest cuts of any department, but a third cut in the civil legal aid budget, a 42% projected fall in the income of legal aid practitioners. But looking at the impact assessment that goes with the Green Paper, up to a 92% cut in the legal aid funding for the not-for-profit sector. And my first question to the Minister would be, how can he defend or explain cuts of that order which effectively wipe out the not-for-profit sector? Well, that would mean to CAB would be a 15% cut in their funding, but to law centres it could mean up to a 50% cut. But in addition, as my friend from Wolverhampton has pointed out, we are facing an uncertain future for the Financial Inclusion Fund. So I echo the question, what is the future of the Financial Inclusion Fund in the new financial year? Because that alone provides 10% currently of CAB funding, and that was praised by the NAO very recently as providing good value for money and a high-quality service. I don't have time to go through each area of practice, but I'm very grateful, and I'm sure the Minister is, for the briefings that have been provided by Shelter on housing, by the Special Educational Consortium on Special Education Needs, and many others, because they highlight the actual effect of these cuts will make to issues like disrepair, to issues like allocations and challenging road land laws. What the SEC says in its briefing, and this gets rid of the idea that these are litigious people or people who are intent on making mischief, as it were, and going to court for no reason. Most parents win their appeals, 82% once they reach the tribunal itself, and 30% of registered appeals the local authority concedes before the case reaches tribunal stage. That's very much the case as regards clinical negligence as well. We must look at the defendants in many of these cases and why they are fighting the cases. Highly respected, large clinical negligence solicitors' practice have told me they will not be taking cases. It will not be economic for them to take cases where damages are going to be less than 100,000 once legal aid is withdrawn.